for your terrific leadership on bringing the ERA forward, and I want to say how moved I am by all of the eloquent statements of our colleagues this morning, and I think it's impressive that we have such a robust turnout on the committee to come for this historic moment. In Democracy in America, Tocqueville said that democracy is always either contracting or it's expanding. And we can look at other places in government today to see how democracy has been contracting and languishing, and we are in a struggle to defend the Constitution even as it is. But one of the best ways to defend the Constitution is to expand the Constitution and to elaborate the meanings that are implicit within it. The whole trajectory of our constitutional development is about expanding democracy to include people who had been subordinated or marginalized or kept outside of equality. When we began, we did not live up to Lincoln's beautiful vision of government of the people, by the people, for the people. We were a slave republic of Christian white male property owners over the age of 21. But it's been through a process of social struggle and constitutional amendment and change that we've opened America up. So after the Civil War, the 13th Amendment abolished slavery, and the 14th Amendment gave us equal protection and due process in the states. The 15th Amendment said no race discrimination in voting. The 17th Amendment shifted the mode of election of U.S. senators from the state legislatures to the people. And the great 19th Amendment, whose birthday we observe next year, whose centennial anniversary we will observe, gave us women's suffrage. The 23rd Amendment gave people in Washington, D.C. the right to participate in presidential elections. The 24th Amendment abolished poll taxes in elections so that we didn't have essentially a wealth qualification test for voting. The 26th Amendment lowered voting to age 18. So the whole movement of our democracy can be read through the Constitution and the 17th Amendment, the 17 amendments we've had since the Bill of Rights were adopted. And everything has moved towards greater expansion and inclusion of people who had not been treated as equals before. The Equal Rights Amendment is an historical imperative from that perspective, to build gender equality right into the heart of our Constitution. Mr. Chairman, I saw a wonderful play by a woman I suspect may be your constituent named Heidi Schreck called What the Constitution Means to Me. And in the play, she talks about how when she was a kid, her mom would take her to American Legion competitions to talk about what the Constitution meant to her, and she would talk about it and speak about it. But then the play takes a dark turn for a moment, because it turns out that her mother and pretty much all of the women and girls in her family were victims of sexual and domestic violence and physical violence. And the play is really about her connecting this trauma in the household to what she was doing, talking about the Constitution, because she said ultimately the Constitution did not include her. And that basic gender imbalance in the original Constitution filtered all the way down to the way that police officers and prosecutors and judges treated women in domestic violence cases and marginalized the voices of women. And so my takeaway from that play was there's nothing better we could do than to give ourselves a new Constitution in the new century than to pass the Equal Rights Amendment. So I'm thrilled that we are going to overcome the rather arcane process objections being made. As you point out, Mr. Chairman, under Article 5 of the Constitution, this is a political question. It's up to Congress to define what the methodology is for adopting a constitutional amendment. The Supreme Court has said that it is a political question, and in Coleman versus Miller, it rejected the idea that Article 5 contains some kind of implied limitation on what Congress can do in the adoption of constitutional amendments. I'm very proud of my neighbors across the Potomac River in Virginia for what a women-led movement did in the most recent election. One of my former constitutional law students, Eileen Filler-Corn, has just been elected the new Speaker of the Virginia House, and I think it will be her great honor to preside over the passage of the Equal Rights Amendment in the 38th state. as a fellow graduate of American University's Washington College of Law, along with Alice Paul, who introduced the very first Equal Rights Amendment back in 1923. So I'm very proud to speak in support of this resolution, and I yield back, Mr. Chairman.